Welcome, welcome, welcome to all of those who have joined the session live or who will be watching this recording later. This is the third session of the Educational and Training Series in the context of the 31st Willem C. Vis International Commercial Arbitration Moot, brought to you by Africa in the Moot and with the gracious support of our media partner, the Arbitration Channel. So for those of you who are new, Africa in the Moot is a non-profit, volunteer-based organization which is aimed at increasing equal representation and diversity in the Vis Moot, specifically of sub-Saharan African teams. And we do this throughout the 8-month journey of the Vis Moot and beyond in other projects that we will come to at a later stage. By supporting through logistics, financial resources, access to education, access to other resources, and most importantly, a platform and a network so that we can empower talented African students to do their thing on an international stage. For those of you who are interested to learn more, please do feel free to contact us. My name is Erin. I am a director of Africa in the Moot and a South African qualified attorney. I am currently based in the Netherlands at De Brouw Blackstone Westbrook, where I practice international arbitration. And I'm very happy to be joined today by one of our Vis Moot and Africa in the Moot alumnus, Mr. Ricardo Mujui, who was a member of the 30th Vis Moot team last year for the Eduardo Mondlane University in Mozambique. But the star of our show today is our speaker, Mr. John Ohaga. We, of course, appreciate all of the speakers, the wonderful practitioners and academics who contribute their time and expertise to Africa in the Moot. But this one is a particularly special occasion because we are joined by John, who is a leading legal mind and legend, and he hails from Nairobi, Kenya, where Africa in the Moot is also based. So this is as homegrown an event as can possibly be in an online setting. But now before I hand you over to John to hear from the man himself, I think it's only courteous to introduce him. If you don't know him already, I encourage you to join the John Ohaga fan club, as we at Africa in the Moot are very much involved in as well. We actually had to cut down his profile because he has a very lengthy list of accolades, but the summary is this. So John is the managing partner at a leading law firm OK in Nairobi. He is a senior counsel and was named Kenya's Lawyer of the Year in 2020 at the Nairobi Legal Awards. He has previously also won the Pupil Master of the Year in 2019 as a recognition of his commitment to mentoring young lawyers, which is a very, very crucial part of practice, which I think is sometimes forgotten. He has been featured as one of the top 50 arbitrators in Africa by the Legal 500. He's on the Arbitration Power List and by the African Arbitration Academy. He was declared the 2010, 2016, and 2017 winner for Kenya in the category of litigation by the International Law Office Client Choice Awards. And in addition, he's an accredited mediator, he's a chartered arbitrator, he's the chairman of the Sports Disputes Tribunal. He also chairs the National Committee on the Formulation of ADR Policy for Kenya. And but again, I feel I'm saying also many, many times over, and this is the short version of his successes and his accomplishments, by the way. But he was recently nominated by the Republic of Kenya to the Exit Panel of Arbitrators and Mediators, as well as to the ICC Commission on Arbitration and ADR. So I take a breath now, and I hand over to John, who will be sharing his expertise from practice and his very vast and full career on building your case from foundations to the finish line. And just one practical note is please do engage with questions. Please put your questions in the chat. There will be a time at the end of John's presentation where we will come to those. So I leave it now to John, and please enjoy.
Brilliant. Good evening, everybody. And thank you very much, Erin, for that introduction. Very flattering, but thank you. And thank you for inviting me. It really is exciting for me to be here with you this evening. It is 7 o'clock in Kenya, so forgive me if it looks a little dark. It does get very dark quite early here. Now, so I've been asked to speak about building your case from foundation to finish line. And there is so much in there that I've had to struggle to think about what what the content of my delivery should be this evening. But as I was thinking about the content of my delivery, and I've been thinking about this throughout the week, in the last 2 weeks since I was invited to speak to you. And on Monday, the 23rd of October, for those of you who might follow arbitration, especially international arbitration, closely, you will be aware that the English High Court delivered its judgment in the setting aside proceedings or the challenge proceedings in relation to the case of the Federal Republic of Nigeria versus Process and Industrial Development Limited. This for me is particularly instructive because we're speaking about arbitration in Africa. We're speaking about preparing arbitration practitioners in Africa. And so I think we do need to be aware of unfolding jurisprudence and the issues that it throws up. And so before I commence my discussion on building your case from foundation to finish line, I would like to touch very briefly on this case because this case got to the finish line, or so the claimant thought, and has now been taken right back. And the case is loaded with different aspects of different learnings, both for arbitration practitioners, counsel, as well as for arbitrators. The case is particularly interesting because A, it was a very significant award. The award was for $6.6 billion US dollars, with interest at 7% per annum. By the time it was being reversed by the High Court in London, the award was for $11 billion. Secondly, the tribunal was a very experienced tribunal. It was a tribunal made up of Sir Anthony Evans, who had been nominated by the claimant, by my very good friend Chief Bayo Ojo, son, senior advocate of Nigeria, who was nominated by the Federal Republic of Nigeria. And the chair of the tribunal was none other than Lord Hoffmann. And so you can see how experienced the tribunal was. Nonetheless, the judge in the English High Court found that the tribunal had been unable to, as the judge himself said at paragraph 580 of his decision, he said the arbitration was a shell that got nowhere near the truth. And I think that is an astounding comment by a judge to make in relation to an arbitration conducted before such an eminent panel. The judge found that the award had been obtained only by practicing the most severe abuses of the arbitral process. Again, that was an astounding finding. And in considering arbitration as a dispute resolution mechanism, the judge expressed the view that the matter touches the reputation of arbitration as a dispute resolution process. But there were other aspects of the award that were of interest. Number one was the fact that the arbitrator nominated by Nigeria, Chief Bayo, dissented. And so it was a majority award by Lord Hoffmann and Sir Evans, which I think should have been the first red flag, because when a tribunal has a dissenting view, then it spurs the appetite for challenge by the losing party. more often than not, the respondent. The other very interesting aspect of this decision and this challenge, in fact, for us students of arbitration is that Nigeria's claims in the challenge included allegations of corruption against its own lawyers. And so it is instructive for us as arbitration practitioners to recognize that the way in which we conduct our proceedings when we are representing clients, whether claimant or respondent, can be brought into scrutiny, even by our own clients. In this case, fortunately for the lead counsel, Mr. Shapshore, senior advocate of Nigeria, the judge found that the allegations of corruption were not made out. But nonetheless, those allegations were made, which is serious enough as it is for any practitioner of any standing, I would say, at any bar. The judge also made other comments regarding arbitration as a dispute resolution mechanism, which I want to touch on very quickly before I go into discussing the main topic today. What the judge said in his decision is that the risk is that arbitration as a process becomes less reliable, less able to find difficult but important new ground, and more vulnerable to fraud. The present case shows that having, as here, a tribunal of the greatest experience and expertise is not enough. Without reflection, then a case such as the present could happen again and not reach the court. In other words, he was saying that notwithstanding the manner in which a case is presented before an arbitral tribunal, if there are deficiencies in the manner in which the case is presented, those deficiencies could potentially lead to the reversal of an award such as had been obtained in this case by process and industrial development. The neutral citation, for those of you who would like to find the case, if you haven't already found it, is 2023 EWHC 2638 in brackets commercial. And I'm sure that you can Google the case and find it located very quickly. I would commend it to you to read and to appraise yourself of the facts and the various twists and turns that you could find yourself in when involved in a high-stakes arbitration such as this. And so that was, as I said, a case that had reached the finish line and had then been reversed and finds itself essentially having come up empty. Which is why it is particularly instructive, I think, this evening that we should be talking about building your case. Because the whole purpose of commencing an arbitration is to obtain an enforceable award. That is the purpose. And I say this on the basis or on the assumption that you are acting for the claimant. And as I informed in the first instance, with respect to your moot problem, you are considering the case for the claimant. Down the road, you will reverse roles and will then be considering the case for the respondent. So I will try to speak about the case for the claimant as well as the case for the respondent, so that we have a flavor of both sides. So the first consideration in building your case, I would suggest, is to identify, as you must, who it is you are building the case for. Are you building the case for the claimant? Or are you in fact instructed for the respondent, in which case you would be resisting the claim? But even if you are resisting the claim, you have to consider the question whether there is a counterclaim or a potential counterclaim, in which case you would once again be in the position of the claimant and would have to then both build and resist. And so it applies to your circumstances. So the question is, if you're for the claimant, what do you need to prove to be successful? Because in order to be successful in any adversarial dispute resolution process, whether litigation or arbitration, you have to prove your case. And you have to prove your case to the requisite standards. So we all know that in civil proceedings, at least in common law countries, the standard of proof is on a balance of probability. And so you must have in mind what the standard is and what it is you need to prove. But it is not sufficient just to prove your case. Because in the end, an arbitration would ordinarily deal with contractual relationships. You are not mounting a case as an academic exercise. You're mounting a case in order to pursue an award of damages. So there are two facets that you must give very careful consideration to. Number one, you need to prove your case on liability. You need to demonstrate that in fact the respondent is responsible for the breaches that you allege, and that those breaches have led to the place where you can establish liability. Because unless you can establish liability, you cannot even begin to move on to demonstrate the damages that you are seeking to recover. So, having established liability, you then need to move on and establish the amount that you seek to recover, which would ordinarily be, it may very well be a liquidated amount if it is for a specific amount that you are amounting a claim, or it may be for damages which would need to be ascertained by the tribunal. In that case, then, you must understand and appreciate the nature of damages that you seek to recover. Because, as you know, damages are divided into their various categories. You might be seeking to recover consequential damages. In very exceptional cases, you may be seeking to recover aggravated damages. And you may be seeking special damages, which have their own place. So that therefore, in considering your factual framework and in putting forward your case, in thinking about your claim for damages, you then have to consider the question whether it is enough to have your witnesses of fact demonstrate the claim for damages and the amount to which you claim to be entitled, or whether you will require to retain the services of a damages expert who is well versed in computing and demonstrating the basis for which you might claim damages. And it is often forgotten, I find, amongst a lot of practitioners, that you actually do need to deal with the question of interest. Interest can be a significant component of the amount that you eventually recover. Interest can be compound or simple. You need to deal with that. What is the basis of your claim for interest? What is the rate of interest that you are seeking to recover? When should interest begin to run? Is it from the date of breach? Is it from the date of the award? Or is it from another date which you need to identify? But you must, in any event, satisfy the tribunal that, number one, you're entitled to interest, and secondly, that you are entitled to a certain rate, you're entitled to compound or simple, whatever else it is that you need to demonstrate. And lastly is the question of costs, because costs, as you know, arbitration, and specifically international arbitration, can be expensive. And what you want to be able to do is to recoup your costs. But again, you have to give serious consideration to A, what those costs are, and B, what proportion of your costs you should be able to recoup, and C, whether there are any aspects of the manner in which the matter has been conducted which may detract from your being able to make a full recovery of your award for costs. Now, having said that, there are various other permutations which add to the complexity of your role, which I do not want to go into at this stage. Perhaps at another forum we may have the opportunity to go into it. Now, we of course assume that your dispute resolution forum is arbitration. Arbitration is consensual. Arbitration is the result or is agreed to by the parties in their contractual arrangement. But arbitration may be ad hoc or it may be institutional. The two have, there are different considerations that you give to those when you are considering what it is that you need to do in relation to commencing your arbitration. But I've always, and I'm of the increasing view, that any arbitration practitioner who is not alive to and well versed with litigation processes is not sufficiently competent. And my view of this, and I try to say this as delicately as possible in the forums in which I speak, because arbitration is inextricably intertwined with the court process. In the end, arbitration depends for its efficacy on the support of the court. Arbitrators cannot on their own enforce their awards, which is why courts have the jurisdiction to enforce arbitration awards, and when an arbitration award is enforced by the court, the award then takes on the force of a judgment of the court and becomes enforceable in the same manner in which a judgment of the court in whatever jurisdiction would be enforced. And hence, as you know, the attraction of arbitration, and specifically the attraction of international arbitration, because then your award is essentially portable and can be enforced in the courts in the jurisdiction in which the respondent has assets. But having said that, you must also recognize that courts also have the power to set aside or to reverse the awards issued by an arbitral tribunal. And so this is a two-pronged power that is available to the courts. And as an arbitration practitioner, you must commence your arbitration being very careful to ensure that throughout the process, you essentially safeguard the enforceability of your award. In my view, as a practitioner, when I act for claimants, I am careful to ensure that the tribunal acts in a manner that does not give the respondent ammunition to attack my award when it is eventually published. Which means that as representative or counsel for a claimant, I feel that there is a responsibility to safeguard the integrity of the arbitral process. And this brings me back to Federal Republic of Nigeria versus Process and Industrial Development. Because the award there was set aside on the basis of deficiencies both in the conduct of the arbitration and in the manner in which the claimant, Process and Industrial Development, obtained the evidence that it required to obtain in order to mount its case against the respondent. And the court found that there had been significant breaches of the safeguards around legal privilege and confidentiality, for instance, interference with witnesses, suppression of evidence, and so on and so forth, which was sufficient for the court to arrive at the conclusion that the award, it was not safe to uphold the award. And so there is a significant onus and responsibility to safeguard the integrity of the arbitral process. Now, as counsel in whatever role, whether for claimant or the respondent, there are various basic fundamental principles around arbitration that you must be aware of, and that I would assume you are aware of already. Those relate to issues, for instance, regarding party autonomy, the doctrine of separability, for instance, the fact that the arbitration agreement is separable from the agreement or the contract entered into by the parties and survives the termination of that contract. Principles relating to the jurisdiction of the tribunal to determine its own jurisdiction. That is the principle of kompetenz-kompetenz. The importance of the seat of the arbitration, and what is the relevance of the substantive law, the governing law. Because each one of those components are important as part of your toolkit in advancing the claim for your client. One, in fact, instructive aspect back to Federal Republic of Nigeria versus Process and Industrial was the fact that at some point in the arbitration proceedings, the High Court in Nigeria issued an injunction, an anti-suit injunction restraining the arbitration, or restraining the parties from participating in the arbitration. Now, this was a London-seated arbitration. And because it was a London-seated arbitration, any arbitration practitioner would recognize that the tribunal was within its right to ignore the injunction order issued by the High Court of Nigeria, because the High Court in Nigeria had no jurisdiction to interfere with the arbitration process, precisely because the parties had chosen London as a seat. And the principle of the seat of the arbitration has consequences which you must be aware of. And again, that is a whole other forum that we will need to engage in. Now, having set out what I consider to be a very quick background, you are now prepared to go forward as a representative for the claimant. You have your contract. In the case of your Moot problem, the parties, as I've seen, are Censor, X, and Visionic. You want to focus firstly on the dispute resolution clause. You want to ask yourself the question, is it valid? Does it cover the dispute? How many arbitrators does it provide for? How do you identify and select your arbitrator? Because as a party representative, that is a very, very important and strategic aspect of the commencement and conduct of your arbitration, because there are nuances which may be important to you later in your case. In the case of Federal Republic of Nigeria versus Process and Industrial, it is instructive that Nigeria appointed one of its own countrymen, Chief Bayo Ojo, Senior Advocate of Nigeria, as its arbitrator. By way of some background, he was a former Attorney General of Nigeria. He's a very experienced arbitrator. And when you think forward to the eventual publication of the award, you will see that he dissented, and that his dissent essentially helped to give Nigeria the platform to challenge the award. So his choice, his choice by Nigeria, was strategic in that respect. That is not to say that your choice of arbitrator means that the arbitrator belongs to you. The arbitrator does not belong to the party that chooses him or her. And there can be no presumption that the arbitrator that you select for your dispute has any obligation to assist your case or to find in favor of your case at any stage of the proceedings. That is very, very important to understand. Having said that, there are nuances, especially when we speak about international arbitration, which may best be understood by an arbitrator who is keenly aware of the environment in which you operate, the commercial environment, the nuances, the peculiarities of that environment, and so on and so forth. Recently, Erin and I were conducting an arbitration training for counsel in Arusha, Tanzania, and a very interesting aspect arose, which was the fact that we recognized, initially with some amusement, but upon deeper reflection, it became quite serious, that when the students or the counsel that we were tutoring went off to discuss their case and to discuss their case strategy, they actually conducted their discussions in Kiswahili, because that was the language that they were most comfortable with. And they then came back to conduct the moot problem in English. But in the course of their conducting the moot problem and their respective cases in English, it was clear that sometimes they would think in Kiswahili and translate that into English and then be able to express either the arguments that they were seeking to make or the questions that they were putting to various witnesses and so on and so forth. And I was sensitive to that because Kenya is a Kiswahili speaking country, and so I was very well able to understand where they were coming from. But we had a co-arbitrator as part of our faculty who was from a different jurisdiction and who was critical of the fact that they needed to discuss their case in Kiswahili before coming to speak or to address the tribunal in English. And in his view, that was a deficiency. And I took a different view respectfully. But that brings me to the relevance, as I've been trying to demonstrate, of the choice of arbitrator, because you would like to select an arbitrator who, for want of a better word, may be sympathetic to your environment, may be sympathetic to the way in which you express yourself, may be sympathetic to your legal system and your processes. Subsequently, we conducted the same training in Nairobi. Erin, you were not there then. And we were discussing nuances and cultural differences. And again, the same issue arose, but this time by way of anecdote. And the anecdote from one of the faculty was that when she was conducting as counsel an arbitration relating to an African country in respect to a dispute between an African country and a South American country, but in which the arbitrators were all either American or from Europe, the arbitrators were extremely suspicious of the emails that had been produced on behalf of a government entity in the African state party. Now, their suspicion arose from the fact that those emails had been sent from a Yahoo account, and they could not understand how a government entity could have emails emanating from a Yahoo account. Because in their experience, every government entity has an email address that identifies it, and that is really, one that is either, if you are in government, it might be the particular entity, .uk or whatever it is, whatever jurisdiction and whatever domain you use. And Yahoo is generally thought to be an email address that would be used by the general public. But I'm particularly aware that even in this country, my country, there are many government bodies, including our judiciary, where Gmail continues to be an accepted email address and form of communication. Now, if you did not have an arbitrator on the panel who was alive to those nuances, it may well be that each of those emails would be treated with suspicion by the tribunal and insignificant weight given to them. And so this is, for me, a very, very important aspect of choice of arbitrator. especially as I am speaking to an African audience, and especially as we are preparing African arbitrators. Now, having said that, I was dealing with the dispute resolution clause and dealing with the identity of arbitrators. There are other aspects that you need to identify. What is the seat of your arbitration? What is the language? What eventually will be the place of arbitration, or rather the venue, because sometimes we use seat and place interchangeably. So I would prefer to use venue. And what is the difference between the seat and the venue? Are you aware of that? Now, then next we look at the governing provisions of the contract between the parties. Because your course of action springs from the contract, what are the provisions of the contract that you allege have been breached? Having identified them, you must then identify what are the facts that support your allegation of those breaches. In every relationship between parties who are in a commercial engagement, there will be interaction which may result in your course of action. But you must be able to distill that interaction and to identify what I call the primary facts, because those primary facts then form the pillar of your case. What are the pillars of the case that you seek to build against the respondent? And what is the factual matrix that makes up that pillar? And then there are other facts, which I like to categorize as secondary. Now, secondary facts may be important in supporting the primary facts, but they may not necessarily be determinative of the allegations that you make. I think also that it is naive when you're preparing your case not to have regard to the potential defense that you might be facing. Because by the time a party comes to you with a factual matrix that it says establishes its case, that will include all the communication established or that has transpired between itself and the other party. That communication should point you to the possible nature of the defense that might be mounted. And so you want to put yourself almost in the position of the respondent and to say to yourself, what would I put forward if I was the respondent? And so therefore, I like to try to plead my case both aggressively but also defensively, in the sense of anticipating what the potential defense might be even before the full defense is brought out. And that means, therefore, that I have to identify what were the parties' respective obligations, what obligations did my party meet, and where did my party fall short in meeting its obligations. If it fell short in meeting its obligations, are those shortcomings sufficiently serious to enable the other party to have a complete defense against my case, or are the omissions relatively minor? This is a weighing up exercise that you must undertake, because it is in undertaking this weighing exercise that you begin to put together the documents in support of your case, as well as your witness statement, of course, together with your statement of claim. every relationship and every claim is a story. And so, what is the story that your claim is putting forward? And I find it particularly attractive when counsel express their case by way of a story. But like all good stories, the stories are told chronologically in the first instance, because facts normally flow in a logical, chronological manner. And so I would suggest to you that in setting out your witness statement, you want to set it out chronologically, from the inception as to how the parties' relationship commenced, how that relationship was consummated, how the relationship was conducted, when the relationship broke down, in what manner did the relationship break down, and what do you say are the consequences of that relationship. But if you have watched a lot of good movies or read good stories, you will know that there are always flashbacks. And this is the way in which we like to present your case. You present it chronologically and then flash back to where you think the tribunal should pay particular attention because of its interrelationship between your allegations at the end and the commencement, or something that happened in the relationship between the parties, or when the breakdown occurred, and so on and so forth. And I am certain that you have picked up these nuances in the course of your considering the problem question that you are faced with. Now, you all know that good facts do not necessarily lead to a successful outcome. And that is because we are lawyers. Facts must be placed in the context of either the legal framework in which the parties are relating, and that may be either the regulations or the statutes or whatever soft law applies to the relationship between the parties. So what is that legal framework? How does that legal framework support your case? But also you must be aware of how that legal framework may very well impede your case, or may very well present obstacles to your case unless you can find a way around a particular legislative framework that you consider to be an obstacle. In the case of the factual matrix that has been put before you, one of the things that I picked out was in the framework agreement entered into between the parties, they have designated a particular seat and a particular governing law, but in the formal orders that have gone out, the party has brought in some other framework, brought in the CISG. How do those interrelate? What is the relevance of that? What is applicable? Those are things that you have to think about. Those are things that you have to confront. And ultimately, if you're to be successful, those are aspects that you have to circumvent. Now, you then very fast forward come to your hearing. You are now before the tribunal, you're ready to tell your story, you're ready to present your witnesses. Who are your witnesses? Are your witnesses sufficiently comfortable with the facts? Are they well versed with the relationship between the parties? Is there anything in their history that might impede you? You want to know. Have they interacted with the other side in a way that might potentially compromise them as witnesses? You want to know. Because again, it isn't simply that you have a good set of facts that leads to a successful outcome. It is the way in which you put forward your facts and the ability of your facts to stand up to scrutiny. The scrutiny of your facts includes a scrutiny of the witnesses putting forward your facts. And you must always be aware of that. That the witnesses putting forward your facts will also be scrutinized. Your documents, document production, discovery. Discovery is an especially powerful tool. As arbitrators, you want to familiarize yourself with the Redfern schedule. Go away and look it up and ensure that you know how to use it. Again, it is, I don't have enough time to go into that. As you know, when you go into a hearing, you then have the opportunity to, whether you're for the claimant or for the respondent, to make your opening statement. The opening statement gives you the opportunity to tell the tribunal what your case is about, how you will go about demonstrating your case, and what it is you will be asking the tribunal for. In other words, you're shining a spotlight into your case and saying to the tribunal, this is my case, I'm giving you the runway of my case, and I'm telling you what the important facets and pillars of my case are, so that when my witnesses come and as I examine my witnesses, they will be highlighting those aspects of my case. And that is, of course, brings you to your examination in chief, because your examination in chief is the opportunity for you to set out what your case is about, what your factual case is about. In international arbitration today, the practice is for the tribunal to ask you to merely introduce your witness, allow your witness to own his or her witness statement, and to then give your witness over for cross-examination. Cross-examination is where it all either stands up to scrutiny or falls apart. In my view, cross-examination is the most powerful tool in any adversarial dispute resolution process. A cross-examination in the hands of competent counsel is one that can make or break a case. But you must understand and appreciate what the purpose of cross-examination is. Oftentimes, I find that practitioners think that the only purpose of cross-examination is to undermine the case or the facts put forward by the witness that has been presented. But actually, cross-examination also presents the cross-examiner with the opportunity to build your own case. And in many instances, the most powerful way of building your own case is through the answers that you are able to elicit from the witnesses put forward by the other party. And in that way, by breaking down those witnesses and then getting them to acknowledge the strength and the pillars of your case, you are then able to build your own case. Cross-examination also enables you to undermine the integrity of a witness. And there are many ways in which you can undermine the integrity of a witness, whether it is a witness of fact or it is an expert witness. Again, I do not think that there is sufficient time to go into that. Suffice it to say that you need to understand the purpose of cross-examination and to equip yourself to be a competent cross-examiner. In order to be a competent cross-examiner, you also need to understand the difference between open questions and closed questions. Because open questions allow a witness to offer a response beyond the parameters that you anticipated, and in many ways it could potentially damage your case. Closed questions give you a better control over the witness. When cross-examining, it is of the utmost importance to control the witness that you are cross-examining. That means, A, that you must be fully alive to and aware of the full factual matrix of your case, as well as the case put forward by the other side, because cross-examination entails taking the witness through that whole matrix and also being able to identify when the witness contradicts himself or herself, and to point the witness to various aspects of the documents or the correspondence exchange between the parties or the contractual provisions which undermine the evidence that the witness has put forward. As counsel for whatever party, whether claimant or respondent, when cross-examining, you cannot afford to lose control and to become flabbergasted. There are often situations I've come across when counsel begins to engage in an argument with the witness as to the answer given by the witness or the manner in which the witness is providing an answer or some other aspect of the testimony of the witness. It is my view that when counsel begins to engage in an argument with the witness, counsel is very quickly losing the battle with the witness. You must keep calm, you must remain in control, and you must try to control the witness. And then, of course, you have the opportunity, if it is your witness being cross-examined, to have a re-examination or a rejoinder. Again, that is an opportunity for you to smooth over the rough edges that may have arisen in the course of cross-examination. My policy, my advice is, if the cross-examination has been particularly devastating, do not attempt to repair it. Hope that you can move on and find another witness that might show up your case. And at the close of the evidential hearing and in the expectation that you've been able to sustain the factual pillars of your case, you have then the opportunity to put forward your closing submissions. The closing submissions will more often than not be in writing, because tribunals prefer written advocacy, but you might have the opportunity also for some oral advocacy. This brings me to the use of authorities and to the manner in which authorities may be used to support your case and to undermine the other party's case. Use authorities to establish the principles of law that you consider to be relevant to advancing your case. But you can also use authorities to demonstrate either that the defense is put forward by the other party, or the damages sought, or the presentation of witnesses by the other party should not be taken into consideration by the tribunal, or for some other reason detract from the case put forward by your adversary. So I am very quickly going past my 50 minutes that I had requested. So I'll very quickly make some very quick comments about tribunals in my experience. You also need to be aware of the nature of the tribunal that you have. Some tribunals are passive, some tribunals are more involved. They want to probe, they want to question, they want to be involved, they want to be inquisitorial. You have to be prepared to handle your tribunal as the tribunal presents itself. You want to be aware, so far as you can, of the identity of your tribunal, some idea of what their philosophy is, some idea of their background, some idea of what you think appeals to them, some idea of, in respect of particular aspects of your case, which member of the tribunal you think you should be addressing, because those are sensitivities that come with experience when you've had the opportunity over and over to address tribunals, because tribunals are made up of human beings, and human beings have inclinations, they have biases. Those biases are ones that you should be try to the best of your ability to, I think exploit is the wrong word, but to identify and to leverage in order to make the best possible case for your the party that you represent. And finally, you want to try as best as possible to ensure that when and if you do get an award, that your award is enforceable. Because sometimes that is only the beginning of the fight. Thank you very much. Erin, I think I've expended my time.
Thank you very much. Thank you very much, John. That was excellent, and certainly not only for Mooties, but also for well, students of arbitration like myself, ongoing students. I now hand over to Ricardo, who will manage the Q&A portion. You're on mute, Ricardo.
Okay, I guess now I'm out. Thank you, John, for your presentation. You have mentioned a lot of good aspects that we normally deal with when we are preparing ourselves in this journey. Something very interesting that you mentioned during your presentation was about choosing the pillars of your case when building your case, and this brings me into a very interesting aspect about the Moot, because case and Vis Moot problems sometimes have a lot of complexity and many facts to go through. So the question I would ask you is, what is your advice on how to structure your arguments and choose them properly? Thank you. While we wait for the question from the students.
Thank you very much, Ricardo. That's very interesting question. As I said, when you are preparing your case, the first thing that I have to say is that disputes do not arise in a vacuum. Disputes arise out of a conflict, either in the way parties perceive their activity of the other party in relation to them, or the manner in which they carry out their contractual obligations, and all these present you with a factual metrics. Now, because we are speaking about parties in a contractual relationship, the facts that you choose must be aligned to the obligation that you say the party that is in breach was obliged to undertake. There is no point putting forward facts which have no relation to the contractual obligation. So, first and foremost, identify the contractual obligation. So in looking at your contract, identify the articles of the contract that set out the obligations, and then identify the manner in which the parties went about fulfilling those obligations. Having identified the manner in which those parties went about fulfilling their obligations, it will then become evident to you which facts support the particular contractual obligations that you say were either fulfilled or were breached. In a way, it is like these facts rise to the top. And they rise to the top because you have started off with a filtration process. And that filtration process is the result of your identifying the obligations that were either fulfilled or not fulfilled. Once you've identified them, then that allows you to begin to structure your arguments, because it may well be that those obligations either stand alone or are interconnected. If they stand alone, then you have really cut and dried facts which relate to the obligations. For instance, if there was an obligation to deliver within a certain timeline, and there was either delayed delivery or no delivery at all, really all you're talking about is delivery. And so you want to identify whether it is a date of delivery, whether it is the time of delivery, or the period within which delivery must have taken place. But there might be obligations which were interrelated. So if those obligations, if delivery, for instance, was dependent on the payment, on an advance payment, for argument's sake, then it may very well be that the delay in delivery was the result of a delay in payment. And so therefore, those two facts are interrelated. And it may well be that the party that delayed in making the advance payment is the one putting forward the claim for a delay in delivery. Now, that is obviously then a very compromised position. But what I'm trying to say to you is, once you have identified the contractual obligations and you have identified the facts which relate to the performance of those contractual obligations, it will become clear to you how you should structure your case, and how you should structure your arguments becomes self-evident in my view. I hope that goes some way to answering your question.
Thank you. It did indeed. Okay. Now we are going to have a question from Conradus Kapoku. Okay. He asks, how can one adopt their case building strategy when transitioning from the initial phases to the later stages of arbitration, such as the hearing and post-hearing procedure, cautioning inconsistencies?
What you try to achieve is a seamless process. What you try to achieve is, from commencement, you want to try to think your way through to the end. You cannot prepare your case in a piecemeal fashion. You cannot prepare your case only for, you cannot prepare your case only thinking about your pleading. You cannot prepare your case only thinking about the production of your, the documents in support of your case. You cannot prepare your case thinking about only your case management conference. You must, at the commencement, have the end in mind. That is the view that I take. Now, obviously, the caveat is that there is a significant amount of experience that goes into that thinking and into achieving that. Inconsistency comes about because you have not thought your case through to the end, or you have not undertaken a complete evidence gathering process. If you do not undertake a complete evidence gathering process at the commencement, what you will find is that in the course of preparing for your hearing, you realize that there are gaps in the information available to you or in the evidence that you've put forward, or you realize that there is a significant lacuna brought about by the fact that the response has blindsided you to something that you never knew, some aspect of the relationship between the parties that was never brought to your attention. So you need, I think, in many ways to think about your case as, I often think about it as front-loading. You need to ensure that the preparation of your case is as thorough at the outset as possible to lighten your load at the end. And if you're as thorough as possible at the commencement, then you avoid the inconsistency that you might encounter at the end, and you also avoid the the blind spots that could eventually appear when you begin to conduct your hearing and when your witnesses are subjected to cross-examination. So start with the end in mind. Always start with the end in mind.
Okay, thank you. Okay, we will take one more question, which will be the last one. You gave a lot of good advice on preparing the substance of your case on practical matter. I would ask, what is your advice for working effectively in a team and taking your case to the finish line?
That's always difficult, I find. But I think that to work effectively in a team, you must have a competent team. That means a team that is well trained, a team that is engaged, and a team that understands the case, every facet of this case, irrespective of the aspect of the case that the team is required to handle. And then there must be trust within the team. And that trust includes a trust as to the competence of each member of the team to deal with their particular aspect of the case, and trust that each member of the team has sufficiently prepared themselves to be able to present the case effectively. Working with a team is like a relay. If you have watched the 100-meter or 100 by 100 meter relay or the 100 by 400 meter relay, you might have seen that sometimes even the best teams drop the baton and they get disqualified. You cannot afford that when you're working as a team in the course of conducting an arbitration. because it could significantly compromise your ability to achieve success. And by success, I mean either successfully prosecute your case and get an award in your favor, or successfully resist the case that has been put forward by the other party. And so a team cannot be put together at the last minute. You cannot put together a team, at the last minute on the eve of the hearing. You must put the team together at the commencement. The team must buy into the strategy. The team must be fully aware of all the facts. The team must have discussed the case. The team must anticipate the challenges that they would face and must each be able to deal with every aspect of the challenges that would potentially be thrown at them. Again, back to some of the training that we have undertaken in training counsel in international arbitration. There have been instances which have been very interesting, where you've seen a lack of trust between teams because at the conclusion of the presentation by a member of the team, somebody else in the team would then step in and say, I want to add to what my team member has just said, or their presentation makes it clear that they found that what their team member put forward was inadequate. You cannot afford that before a tribunal when A, you have limited time, B, you're burning money because you're paying the tribunal for their time, and C, you are either prosecuting or resisting a very high value claim. You cannot afford the risks that come with dropping the baton. So those are the aspects of teamwork that I would suggest would be important in being able to work effectively. I hope that, Ricardo, goes some way to answering your question.
Yes, I think that absolutely, John, and we really can't thank you enough again for your time and sharing your knowledge and advice in such a complete way. You said a few times during your presentation and your remarks that you have to start with the end in mind, and I think that's true in two facets. The first being in terms of preparing your case. Indeed, you have to start, thinking of the goal of arbitration is to get to an enforceable award, and you've demonstrated that very, very well. Not only showing the context of the moot and why that's important, but tying it to this recent P&ID judgment that's come out just a few days ago. But I think the second facet is that it applies also to career goals. There's a lot of exciting and wonderful opportunities that come with a legal career like yours and the career path that many of our attendees are trying to establish. So I think it speaks very much to the type of mentor that you are as well, to inspire people with your comments. So thank you very, very much to you, John, for your time, indeed, for being here with us and for sharing so much of yourself. We really, really appreciate it. And then thank you very much also to Ricardo for your commitment to Africa in the Moot and for your time and preparations for the session today. Finally, thank you very, very much as well to the arbitration channel. You don't see them on the screen, but they are the reason that we are also here in such a professional setting and smooth functioning. So thank you to everyone seen and unseen. And well, last but not least as well to those who have participated, and whether that's live or watching the video afterwards, we really appreciate what you contribute to the community, whether you realize it or not. So with that, I wish everybody a very pleasant evening, and we will see each other soon.
Thank you very much, Erin. It was my pleasure. Have a nice evening, day, morning, wherever you are. Thank you very much.
Good. Bye. Bye. Thank you. Thank you, Mr. John.